Here are the key topics that you should revise in land law: co-ownership, trust of land, severance, easement, and mortgages. Usually these are the topics that come up on the exam. There could be other topics, so make sure you review the syllabus of your course and revise all the topics that have been covered and will be examinable. However, good practice is to do selective studying, which means that calculate how many questions you will be required to answer on your exam. For example, if you're required to answer 3 questions out of 6, you don't need to revise it all, revise everything that was covered. You can just revise 4 topics. So you have one as a backup in case you don't get the question that you were expecting. Review the past exam papers, select the topics for revision, then practice answering problem and essay questions on those topics from past exam papers, and do not revise everything. Just focus on those topics that you selected for revision after careful consideration of how many questions you're supposed to answer on the exam and how past exam papers are structured. It is a hard procedure to put in practice, especially when you are a new student and you don't know how this works. So I strongly recommend that you get an expert advice on this. Our tutors will help you. So if you book a tutoring session with us, we will help you implement this tested method of selective studying. Use the IREC structure, issue rule application conclusion. What is the legal issue in the given scenario? What is the rule, the law that is applicable in this legal issue? How do you apply the law to the facts of the case? And what is your conclusion? Remember, your goal is to identify at least 80% of all the legal issues that arises in the problem question and answer them with critical, detailed analysis. For a first class, they want perfectly clear, critical analysis with relevant case law. So make sure you elaborate on the points. It's not about how many cases you put in there. It's about elaborate arguments. So make sure you focus on that. Today, we will emphasize on trust of land, and that will be our key area of discussion. Trust of land. There are 3 kinds of trusts: express trust, resulting trust, and a constructive trust in land. So what is express trust? According to Section 53 of the Law of Property Act 1925, it's a written document that is signed by the parties. So the parties make an express declaration of how they want legal and equitable ownership to be owned. When there is express trust, the ownership is easier to determine because the intention of the parties are written right there. The dispute arises when there is no express declaration of trust. So in a problem question, the first thing you do is to check if there is an express trust. Have the trustees declared expressly how they want to handle legal and equitable ownership of the property? If there is none, if there is no express trust, then you move to the discussion of resulting or constructive trust. If there is express trust, then it's irrelevant to discuss resulting or constructive trust. What is resulting trust? Resulting trust is discussed in the case of Lloyd Bank versus Rossett, and it refers to direct financial contributions to the purchase price. So let's say a property was purchased for £100,000. One trustee paid 50K, the other paid 50K. That would be 50-50 ownership. So it's directly related to how much money was paid to buy the property by each trustee and made arithmetically calculated according to their contributions. Lloyds Bank versus Rossett. This was a case about a married couple that disputed ownership of their matrimonial home. A house was bought in the sole name of the husband, and the husband was the only one who was who paid for the down payment and then who paid for the mortgage payments. But the wife had not really contributed financially at all. She did arrange some renovation works and redecoration of the house, but she did not really make any financial contributions. As a result, the court held that the wife did not have any beneficial interest in the property. This was in 90, so it's a old case, and that's why it is different than recent cases. This was because she did not pay for the purchase price, neither she made any financial contributions. So before Stack and Dowden in 2006, this was usually the standing of the court on this matter. So if you paid for the property, you get beneficial ownership. If you did not pay for the property, you don't. Period. That's very simple arithmetical calculation of how much was paid by each trustee and then calculate beneficial ownership accordingly. Constructive trust. Over time, the court changed their opinion about this, and they found out that for determining the beneficial ownership, the presumption should move from resulting trust to constructive trust. So it's not just about arithmetical calculation of how much was paid by whom, it's also about other things like intention of the parties. See the case of Stack and Dowden and Jones versus Canada to learn more about how constructive trust operates. Stack and Dowden. Here, Mrs. Dowden and Mr. Stack were a couple living together. They bought a house in joint names, but there was no declaration of trust. So if there is no declaration of trust, that means that there is no express trust. Only then you discuss constructive trust, if there is no express trust. So the dispute arose because they wanted to determine the beneficial ownership. The couple split up. They want to get their respective shares from the property, but they don't know what should be the share distribution of the property. Starting point for determining beneficial interest is to look at the legal title. If the legal title is held jointly, it can be assumed that the beneficial title is also held jointly. So if two people are owning the property, there's a couple, the court will think that it's 50-50 division of the property. However, if they can show contrary evidence, this presumption can be displaced. So this is just a presumption, just a starting point, unless they can show contrary evidence, the court will follow this approach. So the court will look at the parties' shared intentions, actual, inferred, or imputed, with respect to the property in light of their whole course of conduct. The court will look at what did they intend. Was there the reason why they bought the property to provide home for the family? What was the understanding of the parties? Did they intend to buy it in equal shares? Who paid for the bills, for the mortgage, for the down payment, like everything, not just the financials, but every other thing, the whole course of conduct will be considered. And most importantly, the intention of the parties. So beneficial ownership is no longer calculated by looking simply at the numbers, but it's deeper than that now. What kind of problem questions can you get on this topic? You should see our model essay. So if you go to simple studying, if you just Google simple studying, you will come up. So first link, click on that. And then there is a search bar at the top on the platform. You look land law, and then model essays. And you will see a few model essays we have there, including one about this specific topic. This is an example problem question that we have on the platform, but I have simplified it and shortened it. A couple wanted to buy a house, but due to insufficient funds, they got financial help from their parents. They bought a house for £500,000. They contributed £150,000, and the mother of the female partner contributed 350K. Legal owners were the couple, not the mother, but they were all three beneficial joint tenants. The male partner got a mortgage and he could not pay it. So the question is, can the bank take the property? It's a very classic problem question that you may get about trust of land, and you should be able to answer a question like this. The first legal issue would be to discuss legal and equitable beneficial ownership. Who is the beneficial owner? Who is the legal owner? In this case, the legal owners are the couple, both of them, but the beneficial owners are all three of them, including the mother of the female partner who contributed to the purchase price. This was an express trust, so you don't need to discuss resulting or constructive trust because it's already, there is declaration of trust and the parties already expressed their intention in that document, how they want the legal and beneficial ownership to be handled. So no need to discuss constructive or resulting trust. The case of Goodman versus Gallant can be cited for express trust. Legal issue 2, severance, Williams versus Hansman is the case for that. So the second thing you would need to discuss is severance. Has the joint tenancy been severed? Severance can occur when one joint tenant performs an act on his own share. So in this case, what happened is the male partner forged the signature of the other joint tenant. If that happened, if he forged the signature, then severance would occur. Therefore, he would be the owner of 1/3 of the property rather than the entire property with the other two joint owners. You need to discuss all possible grounds of severance because this is the key to determining the bank's rights and for answering the question asked. If the severance occurred, then the bank can only claim the share of the person who got the loan. But if there is no severance, the bank can claim the entire property. Legal issue 3. You need to discuss the bank's rights here. They would only be able to recover the loan from the person who got the loan and his respective share of the property. So the other beneficial owners would not be liable for this loan if severance occurred. Section 14 and 15 should be discussed in this case. Under Section 14, the bank can apply to the court to sell the property. So the bank will want to recover the money. If the person who got the loan cannot pay it, what the bank will do is try to sell the property. So from the proceeds of sale, they can recover the money they are owed. But how can they sell if the other beneficial owners do not want to sell? What they can do is they can apply to the court to order the sale. This is covered under Section 14 and 15 of TLATA, 1996. So it's a statute. The court will consider Section 15, which is a set of reasons why the court should or should not order a sale. There are things to consider here. For example, the court will take into account if there is any minor living there and the welfare of the minor, the interests of the secured creditors, in this case, the bank that granted the mortgage. Also, the intention of the persons who created the trust and why the property was purchased. What was the reason for buying this property? Was it a family home? If it was a family home, does the family still exist or are they separated? So all these things will be taken into consideration when the court determines whether or not the sale of the property should be ordered. For a first class in land law, I strongly recommend you take these 3 steps. First, study with our materials on the platform. Instead of reading thousands of pages in complicated law textbooks, you can read our oversimplified, condensed study notes and model essays to learn everything you need to know to get a first class in land law. Then receive personalized one-to-one tutoring. This is a game changer. Most of the students need personalized support to understand how they should be answering problem and essay questions. You can figure that out on your own using our study materials, because we do have a lot of model essays that will give you a very good idea of how to answer problem and essay questions. And our notes are full of exam advice that will tell you exactly what to do in your problem and essay questions. But most of the students need one-to-one personalized guidance from tutors to get a first class. So I highly recommend that you try that. And finally, attend the free revision classes. If you go to tutoring on our platform, if you open the left-hand side menu, there is tutoring link there. You click on tutoring, and then you will have an option of booking either one-to-one tutoring, which is highly recommended, or you can do group tutoring as well, which is this one, like a class like this, where you will have a revision session in live, and you will have an opportunity to ask any questions you may have to the tutor. So I recommend you do both group classes, revision classes like this, and one-to-one tutoring sessions, which is just you and the tutor one-to-one on a Zoom call discussing whatever you need help with. Thank you very much for attending this revision class, and hopefully I can see you soon.